Board Member Bean is excused or on her way.
Oh, she's excused.
Do you excuse? Board Member Brown,
Present.
Board Member Harper,
Here.
Board Member Rhine,
Rennie here.
Rennie?
Rennie, yes.
Rennie. And then we still waiting for a new appointee by the County Board of Education, Vice Chair Gooding,
Here.
and Chair Asher.
Here. Okay, please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, now is the time for public comments. Seeing no members of the public here, we will move on to item number 3, special order of the day, administration of oath of office to Susan Rennie, did you say? Yeah.
Yes, thank you.
Oh,
That's you, Karen. Now we got to look it up.
yeah, now I have to look it up. I cut my thumb and
There's
just
got to be a
walked away.
website that has
There
it,
has
there,
to be.
Karen. I mean, I'm sure.
I
Oath of
know
Office,
exactly where I can
California.
get it.
Susan's probably done this so many
recite
times.
it.
Yeah.
No, we just get the T's, Karen.
That's right.
So even if you could, you can't.
If you're on 8 boards, you must know it by heart anyway by now.
Berkeley, You get to do anything else? in your,
Yeah,
life?
exactly.
Not at night. And they're, all of the due dates are the same time, so all the meetings, but they're not spread out.
Yeah.
Kind of blurs together almost, doesn't it?
I will go and get a copy for you. So please repeat after me. I, Susan Rennie,
I, Susan Rennie,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support and defend the Constitution of the United States
that I will support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I bear truth, faith, and allegiance
to the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservations
or purpose of evasion,
or what?
or purpose of evasion,
Oh, or purpose of evasion,
and that I will well and faithfully discharge the duties upon which I am about to enter.
and I will well
and faithfully discharge
faithfully discharge
the duties upon which I'm about to
the
enter.
duties upon which I'm about to enter.
Congratulations, our newest Oversight Board member.
Well, thank you so much.
Welcome, Susan.
No reservations.
Yeah,
Mental or,
none.
yeah.
Even with all those meetings. Okay, now we're on to the consent calendar, item number 4. I'll entertain motions on the consent calendar.
So moved.
I have a second?
Second.
Okay, all those in favor?
Is that Harper?
Well, can I, excuse me?
Oh, yes, that, we got to get this
You have an
straightened out.
alternative here.
Yes,
to
and I was
choose from.
moving our attorney's addition.
We have an addition to
The
the,
attorney's, yeah, addition to that. Now, that would need to make that clear, that that's been acceptable, I presume.
did we get an email about this, or is this the updated version that we just,
It was an
A
updated version that
week
went
ago.
out on Friday.
okay.
And the difference is that it was my recommendation that the funding agreement be amended to make it binding on the city that the monies are spent in the Shell Mound redevelopment area. So that was the recommendation. I think Mike and I don't have any disagreement about the fact that that's where it needs to be spent, but the agreement with the city doesn't provide that, and so they're not bound by that unless it's in there. So that was the recommendation.
I can just address that. I think after we spoke, I did look at the agreement itself, and it does obligate the city to, if I can
And it shall
point
not.
you to the section. This is in page 18 of your packet, so it's section 3.5 of the agreement.
Okay, I've got the agreement.
And it just says that the city shall perform its obligations hereunder in accordance with the applicable provisions of federal, state, and local laws. And, you know, certainly the bond covenants itself are an extension, I think, of at least federal law relative to the, you know, the issuance of the bond. So I guess I'm questioning the need to do this. I don't have an objection. I'm just trying to avoid having to put another item on the council and successor agency's agenda. And then I have a question as to whether I even need to do that in my own mind, just to amend the agreement to do what I think we're already obligated to do.
Well, you and I have a disagreement on the law about that, but I think the logic that I get tripped up on is that there really isn't a need for any kind of rules applied to the city for how they spend the money. There's no reason to say that they have to spend it in the implementation, on projects approved, in the approved implementation plan. There's no reason to say that they have to start it by a certain date if everything that's in the bond documents apply automatically.
Well, we have already agreed to all those other things.
Right, but
and
if those are necessary, then it's also necessary to say to the city, you have to spend these in a certain project
But
area.
you have to comply with the bonds.
So,
So,
yeah, we have a difference of opinion on this.
We do, and I'll just leave it at that. And then I guess my question to you and perhaps to the board is whether there is an expectation that we will go forward and once we have the council and the oversight, or the successor agency approve an amendment, which we have scheduled to put on their April 22nd agenda, are you expecting me to then come back
No,
and show
I
that
mean,
to you?
the purpose of doing this contingent resolution was to try to avoid that.
Okay.
And it may not pass muster with DOF, but it was an effort to try to skip that step, frankly.
Well, DOF did, in the staff report I provided to you, I indicated that DOF was saying, well, we might reject this item. They, in fact, did actually approve it, subject to the Oversight Board approving it by resolution. So they did go ahead and authorize it. So I just want to be clear whether you're expecting me to come back and show to you that the city council and the successor agency did in fact do that.
That's not my expectation.
Okay, all right.
I think Greg wanted to speak.
Yeah, I mean, it was only on the basis of my reading that it was harmless.
Yeah, it is. I'm just
And
was
so, yeah, you don't have to come back
Okay.
to us with that, and
okay.
and it's up to you as to whether or not you think you need to go back to the council. And that's
Yeah, well, the resolutions that both the city council and the successor agency adopted had provisions that allow the city manager and myself to approve revisions to the agreement to the extent it's consistent with the intent. But, you know, I think just in case we get any questions from the Department of Finance, once they see the Oversight Board's resolution, I want to be able to follow that up with a official resolution of the council and the successor agency approving the amendment, so. All right, thank you.
This item is approved unanimously by the Oversight Board, right?
With the recommended additions,
Yeah.
yes.
Yeah, with the recommended.
Right.
Okay, yeah.
That was,
Did you get that, Karen?
Greg moved with Gooding, Harper moved with Gooding seconding it, and it was the version that was provided by the council, by council.
Legal counsel,
And it's a 5-0-1.
Okay. All right, on to item number 5, resolution of the Emeryville Oversight Board directing the City of Emeryville as successor agency to the Emeryville RDA to commence proceedings for the issuance of bonds to refund bonds and other indebtedness of the former Emeryville RDA.
Excuse me a second,
Sabrina.
I'm having an issue with the computer. It's locked.
Doesn't affect broadcasting, does it?
No, I just can't take notes.
Timestamp, it won't work.
Yeah.
Okay, well,
Like, my screen is frozen. but
it's
go
okay.
ahead.
Let's
Go ahead.
proceed, please.
All right.
Okay.
So we're before you tonight, asking you to adopt the resolution directing the successor agency to commence proceedings for the issuance of bonds to refund the indebtedness of the former Emeryville Redevelopment Agency. And I'll run through a little background here and can entertain some questions. The former redevelopment agency entered into loan agreements in 95, 98, 2001, 2002, 2004, which was secured by the tax increment and then also the housing revenues. And it was issued by the Emeryville Public Financing Authority. Currently, the outstanding par amount is about $144 million. All of the bonds are callable, which means they can be refunded at par, so without penalty, as of September 1st, so we are moving forward with that date in mind. The Dissolution Act, which was amended by AB 1484, authorizes a successor agency to issue refunding bonds to pay off the outstanding indebtedness of the former redevelopment agency. It details the process we have to go through. Staff has determined in consult with our financial advisor that the market conditions, i.e. low interest rates, and an appetite for these bonds in the market, make this a good time to go forward and refinance the bonds. The preliminary estimates are showing an annual savings of approximately $500,000. Just a recap of AB 1484, it allows the successor agencies to refund the outstanding tax allocation bonds, or TABs, as you all are probably familiar with. It requires the Department of Finance to approve the refunding after the Oversight Board, successor agency and the Oversight Board both approved. Refunding of the TABs cannot increase the debt service, nor can it extend the final maturity of the bonds. Savings is shared by all the taxing entities, including the City of Emeryville, and all of you. Since the adoption of 1484, there's been approximately 31 tabs that have been refunded, and we're aware of quite a few that are going to be going forward in the next 6 months or so. So this is something that was anticipated as part of the wind-down legislation. No one can see this, but it was included in your packet. It details what our estimate is of the annual savings. It's the second row from the bottom, shows you what that total amount is estimated to be on an annual basis. And I believe, if I can read it from here, it's about $566,000. Again, each of you would receive your portion of that as one of the taxing entities. For example, the City of Emeryville receives 22% of that, which I think says $124,000 per year. Refunding consideration. So refunding all the 7 bond issues would produce positive net present value savings. We're looking at savings that would range from about 5.8% to 13.6%, with the exception of the 2004A bonds. Even though there'd be marginal savings for that bond, we're actually still recommending that we refund all of it, just so that we have an efficient legal structure. There are considerable administrative benefits from refunding the 7 bond issues. And as I mentioned before, earlier, the annual savings will be approximately $500,000 per year, or $6 million over the remaining life of the indebtedness. And then the city share, as I mentioned, is about $100,000, and you all would also receive your portion. So tonight's action, we're asking for you, again, to adopt the resolution directing the successor agency to commence the proceedings for the issuance of the bonds to refund indebtedness of the former redevelopment agency. I will note, we mentioned it in your staff report, that this item was going forward on April 1st to the successor agency. They did last week authorize the retention of the following consultants that are necessary to complete the refunding, but that's contingent upon you all giving the direction today to go ahead, and that included our bond counsel, financial advisor, and fiscal consultant. So next steps, so we're here tonight, you would give the successor agency the direction, we would go forward and prepare the legal financing documents, hire the underwriter, but we would come back to both the successor agency and the oversight board next month on May 6th and May 7th respectively, with all of those documents. The Department of Finance, as I mentioned, will have to approve the refunding. We would secure the credit ratings and possibly some bond insurance, and the successor agency would approve the disclosure documents on July 15th. We would price and close the bonds in mid-August and in early September, and move forward from there. That's the presentation.
I have a question.
Questions, Aisha?
Just to kind of, Sabrina, just to clarify the time frame for the DOF to approve, how long is that still within the normal window that they approve?
I don't know that answer. Do you know
I'm
the
sorry.
answer?
What was the question? I'm sorry.
Sabrina, in her presentation, she mentioned that the DOF needs to approve this process. So do you know the time frame in which they normally take to approve?
No, I don't know. And hopefully that they'll be accommodating and swift, because they know it's going to save everybody money. I think we should be all headed in the same direction on this one.
Okay.
So so moved. I move the
Do you have a
resolution.
question, Greg? Yes, or
Yeah,
comment?
well, I have a disagreement, and the only, I would move for severance if it doesn't, is that transaction costs, which are the only thing that are allowed, are much more restrictive than administrative costs. I mean, in any kind of bond transaction I've ever been in, it's obvious that it's third party, you know, the cost of doing that. I mean, I'm not sure that the financial advisor might be included in some other things, but I know that transaction costs when you're dealing with a financial instrument, and that's all that's being allowed, would not include the administrative. And I don't want to be part of Section 3, which is what I consider an overreach of the statute, which includes the cost of reimbursing the city of Emeryville for administrative staff time with respect to the authorization, issuance, sale, and delivery of the bonds. Because I think the transaction costs are very understood in the securities market, and that's not a transaction cost. And when the legislature said that you're allowed transaction costs, it meant exactly that.
Do we know what has happened with the refunding of bonds in other cities? Have they structured it similarly in terms of reimbursing staff time and the other things that Greg is pointing out?
I believe so. I mean, the language that we have there comes from our bond counsel, who has been working on these bond deals out there. So
Okay.
We can come back, when we come back to you in May,
That's
we can give you
something
some clarification.
That we want more information
I will
on?
tell you, on the cost of issuance, the numbers that I provided there are all net of the cost of issuance. On the administrative costs, I mean, we're really talking about, you know, if we were to charge some of my time or our attorney's time, but I'm not really anticipating doing so. I'm not exactly sure why that language is in there, but you can.
Yeah, and
So that came from bond counsel?
yeah, it came
Okay.
from bond counsel, and I think already, to the extent that staff spend time on this, we would already be able to charge our time against that, because we already have an administrative cost allowance that's always a part of the ROPS. So,
It's not beyond that?
so, you know, to the extent, you know, when I work on things related to successor agency dissolution, I charge my time to that. And this, in my view, working on this would be charging it to that existing line item that we have already, so I'm not sure why that's, I'm not sure why that's in
I have no problems
here.
with that. I don't know why this is necessary, because it seems to me that you're just asking DOF to say, no, that's not allowable, if it's in there.
Yeah, I don't have any objection, because as I say, we'll, to the extent,
But if section 3 goes out, I've got no problem with it. It's a good idea. It's win-win for everybody.
What does the rest of the board have to say? Or Paula?
It's just reinforcing that the 34,177.
It's, can I address the board?
Sure.
So this comes from, what is this? It's section F, Mike. And so this is why bond counsel is doing it this way. Instead of just letting the successor agency go ahead and do this and then come to you at the end of it to ask permission before it goes to DOF, the law says that if the oversight board can direct the successor agency to do this, so long as the successor agency is able to recover its related costs.
Transaction, related to transaction.
Yeah, related to the transaction, right.
Transaction cost.
Right, and so I guess, so Greg, you're reading that, let's see, cover its costs. Well, but section 3, and this is the way I looked at it, it's tied to section F,
Right, which,
and it says its costs in connection with the proceedings.
do you have the code in front of you?
Yeah, I do.
I'm just curious what it says.
Yeah, well, that's what I was just reading.
Oh.
It says, "As so long as the successor agency is able to recover its related costs," I guess that's the word, is the related costs in connection with the transaction.
Okay, so, I mean, if I understand, Greg, you're really asking just to excise out the phrase, including the cost of reimbursing the city of Emeryville for administrative time spent with respect to the authorization.
right, I mean, and you can, to me, I've got no problem with you asking for it. I've just got a problem saying that it's appropriate, in my opinion, to be within the statute when I just
Yeah, I
don't
mean, the
think it is.
statute doesn't specifically call it out, and as I say,
You get them
we can
anyway.
take it out and we can charge it elsewhere as part of our administrative cost allowance that we
Exactly.
receive anyway, so I don't have any objection.
Susan?
Didn't you just say, though, that it was a condition of being able to refinance? Isn't that what it said?
Well, if the oversight board directs the successor agency to do this, rather than the successor agency doing it and coming and asking for permission, then the law says you can direct them, but you've got to let them recover costs.
So we're directing them to refund it.
Right.
And so therefore, we have to
Right.
have something in there that allows them to recover the cost.
Right, but the statute says it related to the transaction, and Greg is pointing out that some of this other stuff may, doesn't fall within that exactly. So I will say that bond counsel did draft this resolution. I made one change because I thought we should give more direction if we had to make findings later. So I have to assume that bond counsel is finding that this has been acceptable to DOF. Because if it's one thing bond counsel does is that it's uniformity and conformity, and it's, safety in numbers. And they start doing this in a way that they find, I mean, they've established a convention on this kind of refunding bond already. And so they're telling every jurisdiction that the oversight board needs to direct the successor agency so that you can be sure and capture these funds.
Yeah, I don't have any problem with trying to do it. I just having a problem with an acknowledgement and agreement on behalf of myself that it's appropriate to do so, which is what Section 3 says.
Yeah.
When I do not agree that that's the case. So,
Okay.
I mean, so in other words, I don't see that, in my opinion, Section 3 being struck does not prevent, if you wanted to do it, and as you say, you may not even want to do it.
Yeah, well, I mean, what I'm saying is that we already have an existing funding source
Right.
with which to charge our time to, and really the individuals that are going to be working on it from the city, you're looking at the two of them right here.
Right, there they are. Right.
Well, Gregor, would you be comfortable if we tracked the language in subsection F of the statute? and allowed specifically for those costs?
Yeah, I mean, it was just what I considered the enlargement into administrative task times.
Okay.
With respect to the authorization, issuance, sale, and delivery of the bonds that I thought was getting past Section F.
So we could take out that last clause
Yeah.
and get it adopted.
So we have a
I'll
motion.
accept that in my motion, but let's get moving here.
Okay, do I have a second?
Are you moving on my little variation on it, which gives them
And
some more
and your
direction?
variation.
Okay.
I'll second.
Okay, all those in favor?
Aye.
Aye.
Excuse me, so that was,
So we're putting a period after refunding bond.
Yes.
so excuse me, so it's the council's version of the resolution again,
But with the last clause in section 3 removed.
with clause 3. Thank you.
No, I'm happy to do that.
Will send what passed. Okay, thank you.
Okay,
Okay, so that was then
Gooding?
Harper with, who seconded?
no,
Gooding
that's
second?
Aisha.
Brown, second.
Gooding moved.
Gooding moved,
Brown,
Brown
second.
seconded.
5-0.
5-0. Okay, I thought Harper was severing the motion, but,
No,
Not
we
anymore.
just amended.
okay.
It ended up being reversed there, but it was okay.
Yeah,
I don't
Okay.
care.
okay. Any other matters? No other matters this evening? Okay, with that, this meeting is now adjourned. Thank you, everyone.
Wow.